So now it's my great pleasure to introduce Margaret Stewart from the Centre for Earth Jurisprudence at Barry University in Orlando, Florida, a place that I was lucky enough to teach for a semester in Earth Jurisprudence. So that was excellent. How are you today, Margaret?
Very well. How are you?
I'm really well, thank you. Last year, Margaret gave a beautiful presentation to us whilst sitting and listening to a massive typhoon outside her windows in Florida. It was a nerve-wracking time, and we have always been in deep admiration of her tenacity and commitment to the cause. Margaret, I might hand over to you now to give your presentation, share screen. I'll collect any questions, and we'll have a quick chat after your talk. So thank you so much.
Hello everyone, and thank you again for having me here today to talk about my experiences in applying the rights of nature principles in practice, as well as teaching it to the next generation of Earth law advocates. So, as our wonderful host shared, my name is Margaret Stewart, and I am the faculty advisor at the Center for Earth Jurisprudence at Barry Law School in Orlando, Florida, in the United States. I'm also now the director of our Environmental and Earth Law Clinic, where the students take on actual legal cases in the areas of environmental and earth law. And I am the governance facilitator of the Legal Hub for the Global Alliance for the Rights of Nature. So if you're interested in joining us after this symposium today, definitely get in contact with me. I'll throw the Legal Hub and my emails in the chat as soon as I'm finished speaking. We'd love to connect. So at the center, we are a team of lawyers who advocate for laws, policies, and governance systems that are aimed to legally protect the sustainability of life and health on Earth. And we believe the best way to do this is by rethinking our legal framework in a way that takes a more Earth-centered perspective. So today, I want to really briefly introduce, how we see this legal philosophy and how it has taken shape in recent years, specifically here in Florida. We have a lot of really wonderful examples throughout the United States, but I know I have some of my co-speakers throughout the rest of the day who are going to zero in on some of those other cases. So I'll focus on the Florida example that Mari just mentioned at the end of her speech, actually. And also, again, a little bit about how we're preparing that next generation of legal advocates to continue developing these types of legal systems throughout the world. So a little bit, there we go. Much like Mari, I just wanted to start off really briefly going through, not just what rights of nature are, but also what they're not. And it's important for us to understand that the rights of nature are not something that we are granting to non-human members of our Earth community, much like we as humans possess human rights simply by virtue of existing as human beings, so do all other members of this vast interconnected Earth community that we belong to. I'm actually sandwiched in between two Earth law, Earth jurisprudence courses right now. I taught one this afternoon and I teach one immediately after this at the law school. And we were talking about the rights-based approach today, and that idea of granting versus recognizing, is something that the students were going through today and understanding the importance of that. So I definitely wanted to start off with a little discussion there. And the idea that we don't have to do anything to obtain our human rights, right? They are intrinsic and inherent to us being human beings, and our laws simply recognize those rights. But we do need that legal structure, right? Because we need this agreed upon systemic worldview in order to have those rights recognized and have them protected and defended. Because as we know, our human rights are constantly under attack, right? Sometimes even legally speaking. And it's not something that is immune from violation. So when they're violated, we need to have some somewhere we can go to obtain recourse for that violation. The same is true for the intrinsic rights of nature. However, we don't currently have that legal framework that allows for that recourse. So that lack of recourse results in a lot of the things that Mari has spoken about already. You know, the idea that we are in the Anthropocene, a new geological age that is defined solely by the destructive impact that human beings have had on Mother Earth. We're also in the sixth mass extinction. Similarly, unlike previous extinction events, is defined by the effect that one species has had on overall biodiversity. So the other question we get is, why can't we just pass another law to address this? Well, ultimately, as Mari explained, as I'll explain through my case study tonight, you know, the foundation that we've built our regulatory framework on is flawed, essentially. And so the laws that we build upon that are going to be on shaky ground, right? And it's never going to quite address the systemic problems. So, you know, we have to take a more holistic, a more ecologically intelligent approach to our legal organization of our relationship with the Earth community. And to do that, we have to advocate for more large-scale systems change. So the important question remains, you know, what does this look like on the ground? And so again, I wanted us to just, for this half hour, to focus on the case that has been ongoing in Florida in the United States, because I think it's a very good example of the tensions that can arise in the advocacy for the recognition of these rights. So here in Florida, we are trying to address the chronic illness of environmental degradation in many ways, but the most innovative way has been the recognition of the rights of various water bodies. So in Florida, water is kind of a big deal for a lot of reasons. It is for everyone, but you know, I don't think we tend to recognize, you know, the central role that it plays in our lives a lot. But Floridians are very concerned with their water. The principal source of groundwater for most of the state is known as the Floridan aquifer. This is the source of all municipal water supplies in the north and central Florida areas. And so I've put up this map here for you to see. The blue portion there is the Floridan aquifer, and that's where large amounts of the state get their water. It also yields yields water to thousands of domestic, industrial, and agricultural irrigation wells. And it's said that there are about 7 billion gallons of fresh water used daily in Florida's agriculture industry, power plants, public water sectors, etc. And most of this is all taken from the Floridan aquifer. In addition, we're having a huge population increase here in Florida. The reliance on these underground freshwater reserves are becoming more and more depleted. In some Florida regions, the freshwater reserves can no longer sustain the growing demand due to the growing populations, and also continue to feed Florida's rivers, springs, lakes. All of those water bodies are also fed from these underwater freshwater aquifers. So, you know, in times of periodic droughts, you know, there's no reservoir to go to, essentially. We also have the problem with over-extraction, sea level rise, the increasing risk of saltwater intrusion into the aquifer, agricultural and urban runoffs. All of these things are straining the water availability in the state. In addition to that, Florida ranks 11th among America's states for fresh seafood production. And in 2016, the Department of Agriculture valued the amount harvested at about 87 million pounds per year. And however, the Environmental Protection Agency has also shown that Florida's current criteria for 40 different toxic pollutants does not meet our Clean Water Act's regulations, and it does not reflect the latest science, and that it has to be changed in order to safeguard the state. And when we put this together, due to the increased consumption of seafood, seafood being such a vital part of the economy, we can see how we're starting to have these building, compounding issues all coming down to our use and abuse of the water systems. So this particular source of water is central to Floridians' culture, their biological, even their economical sustenance. So it should come as no surprise that in 2020, as Mari introduced, that the voters of Orange County had overwhelmingly approved a water rights amendment with a margin of 89.2%. The measure was known as the Right to Clean Water Initiative, and it was the first in Florida to recognize the rights of nature and to empower residents to enforce the rights of waterways and the rights of people to clean water. So it went through a pretty robust procedural process. In early 2020, the language was approved by the Clean Water Committee. It also went on to the Orange County Constitutional Revision Committee, and the language was approved there as well. And then the final language was finally approved to be put on the ballot in the upcoming 2020 election. The point was to secure the people of Orange County's right to clean water and to secure the rights of all the water in Orange County and the language of the ordinance was to exist, flow, be free from pollution, and maintain a healthy ecosystem. It also outlawed intentional and negligent water pollution, and also provided for the enforcement of those rights with corresponding remedies. However, between that approval and the actual vote, the state legislature signed what was ironically known as the Clean Waters Act. And the effect that this act had was to preempt these local ordinances to recognize the rights of nature. It included provision that banned local governments from recognizing or granting certain legal rights to the natural environment, or granting such rights relating to natural environment to a person or political subdivision, is the language specifically. So unfortunately, state preemption has been used in Florida to stop environmental protection on more than one occasion. We've seen similar tactics used to stop local plastic bans, fracking bans, things like that. So there was an attempt by one of our legislatures, Ana Askamani, to put a statute in place in order to preempt the preemption and to protect local municipalities' ability to recognize the rights of nature. It essentially said it would remove any provisions preventing such measures. However, that died on in 2021 in the Civil Justice and Property Rights Committee. So it never made it onto the legislative floor, unfortunately. So that brings us to our latest attempt. No, my apologies. Let me finish up with the case first. So the people voted, the state overruled that vote, so we went to court. And at issue in the case, it's centered around a permit that the Florida Department of Environmental Protection had granted this development company, the Beachline South Residential, in order to dredge and fill waterways for the purpose of constructing residential and commercial buildings. So the plaintiffs here, which included the waterways, due to the ordinance that, while preempted, we still maintain stands, it claimed that the activity would violate their rights, and it asked the court to issue an injunction stopping that development. So unfortunately, that was dismissed based on the argument that the ordinance that the case was relying on had been preempted. So things were going the state's way at that point, unfortunately. But an appellate case has been brought, and the amended complaint states that the development proposed here would disrupt the delicate ecological balance between all the water bodies and numerous species, including rare plant life and the animal life that it supports. It also goes on to say that Florida only recognizes two forms of preemption of local ordinances and charter amendments, and that the state's attempt here to sort of just with one broad stroke prevent any of these ordinances didn't fit into any of those, so that this was an inappropriate use of power anyway. And so the preemption should be preempted and back to the original ordinance being in place. So that's where we are now in all of this, in the legal back and forth of our local ordinance. However, that does bring us to another initiative that is going on right now. The outcome of the case is going to be really important to determining the future of feasible alternatives to environmental protections in Florida. However, in the wake of rising interest in the recognition of the rights of nature, we now have a citizens' initiative aimed at recognizing those rights in the state constitution. This is what's known as a Green Amendment. If you are interested in the historical usage of Green Amendments in the US, I highly recommend reading the book, The Green Amendment by Maya Van Rossum. It does a really great overview of how these state constitutional amendments can be used to recognize nature's rights, human rights to a healthy environment, all of those different things. So what this amendment would do, it would amend the Bill of Rights in the Florida Constitution, specifically implementing Section 28 here with the following language. And I just want to go through the first portion just so we can see what that language is. It says, water sustains all forms of life. Clean and healthy waters protect and promote substantial interests, including human health, safety, and welfare, native fish and wildlife, conservation of natural resources, outdoor recreation, aesthetic values, business opportunities, property values, and economic interests throughout the state. This section provides for equitable remedies against the actions or inactions of state executive agencies that harm or threaten to harm Florida waters, with the goal of clean and healthy waters and the aspiration that waters in the states will one day flourish. So essentially, it creates a fundamental right to clean and healthy waters, and it also clarifies what the prohibited actions and inactions that harm those waters would be. It goes on to define some important terms, and it also allows for Floridians to enforce this right through the ability to sue state executive agencies that violate that right. And it also empowers courts to look at the science behind the cases that are brought before moving forward with an equitable relief to whatever the situation is. So we are currently getting signatures for this initiative. We need about 300,000 of them to get them on the next ballot. And then if that occurs, we will go from there. So this is just a few of the ways that the implementation of the rights of nature is taking hold on the ground, specifically in Florida. As I said earlier, we do have some really wonderful cases from other areas in the United States, but I'm certain that my fellow speakers will be addressing those as well. So we are still actively looking for alternatives to our current legal framework that we've had in place for 5 decades now. However, we still see the continued deterioration of the health of the planet that sustains our own lives as well as the lives of the rest of the Earth community. So I always like to share this quote from Thomas Berry. It says, "We cannot have well humans on a sick planet. We cannot have a viable human economy by destroying the Earth economy." In other words, we need to move the basic referent from the human to the larger context of things. And I believe that that's what these rights of nature initiatives are attempting to do. It's attempting to look beyond the human into the greater context of things and show that, you know, we do have this interdependent relationship on the Earth community, and that we need to start accurately reflecting that into our laws and policies. So as we've seen, there has been some pushback to that, but we do believe that we have some strong legal arguments to push back once again and hopefully get some of these ordinances and initiatives moving forward. So I just wanted to end with our contact information. If you are interested in supporting any of this work or hearing about the work that we do at the clinic, or if you're interested in joining the legal hub of the Global Alliance for the Rights of Nature, I will put all of that contact information into the chat, and please, you know, like and share and all that good stuff, all the ways we spread good information these days. So I'll end there, and if we have any questions, I'd be really happy to hear them.
Thank you so much, Margaret. It's really wonderful hearing about all these developments in different parts of the world. And for those who've just joined us, there are a number of new folks. Margaret is our second speaker today, and Margaret's given an overview of some of the rights of nature developments in Florida. But her organization, the Center for Earth Jurisprudence, is also actively teaching Earth jurisprudence and rights of nature to young law students, which is terrific. Margaret, can I just ask, we've had a private question, someone who got confused with the preemptive and the emptiveness. Are you able to explain to a non-lawyer right now in Florida where, so that last bill it's not really a rights of nature bill, but it is looking at human beings' right to healthy waterways and such. Where exactly is the rights of nature or the rights of waterways bill or laws up to at the moment? Can you just recap that for folks who might have come in a bit late?
Absolutely, yes. And I'll just briefly run through these slides so that we can see. So we started with the rights of waterways in Orange County. So that's where we started. So Orange County is this area in here around Orlando, one of the largest counties in the state, and the largest municipality to pass such an ordinance in the United States. So we started there in 2020. After the language for the ballot was approved, but before the election, so before it was voted on, the state passed our next slide, the Clean Water Act, which in it, in Section 9A, had this provision that said that local governments could not pass rights of nature ordinances.
Right, so you had the local government passing this act, then the state government overruled it and said you can't do that. Okay, next.
Exactly. So then we ended up in court. This is the appellate cover sheet here, but the initial case went to court to say, that case pretty much argued that preemption shouldn't have existed, and they brought a case based on the rights of the waterways. Okay, so the case was brought as if the ordinance was in effect, as it should have been, because it passed with 90% support. So that case was dismissed because the court held that no, this preemption, is valid. It does preempt your ordinance. So you have no basis for this case. This is the appellate case that was just brought about 2 months ago or so. And in this, they are arguing that there are certain requirements for preemption in the state, and that this blanket, you just can't recognize the rights of nature, does not fit within any of those requirements. So they're still arguing that this development project should not happen based on the original ordinance, and that the state's preemption was inappropriate. This is where we are now. No decision has been made on this.
Right. So technically speaking, the Rights of Nature bill passed in Orange County is not in effect at the moment, but it's sort of being debated and discussed by communities and trying to be defended by communities. Would that be right?
Correct. Yes.
Okay.
Yes. So effectively, it never did go into effect because, in looking at the timeline, the preemption was before the vote.
Interfered with it.
Because cool. It had already been approved, it stayed on the ballot, so it was this weird little situation that occurred. But regardless, passed with 90% support. So
and this is just a snapshot now, isn't it? As people continue to defend that initial attempt at making law, I'm sure these processes will move and change. Thanks, Margaret. I just want to share with you, I think one of your students might be online. I'm not going to dob in his name, but he said, Professor Stewart is awesome. So extra points for Zachary, yeah?
Yeah, great.
And well, so this amendment is not so much rights of nature law, but a right for human beings to clean water, which I think a lot more people understand the concept.
Exactly. Yeah. So for the state initiative, they went to Maya Van Rossum for assistance in drafting that. And yeah, the green amendments that have passed in states have taken the human right to a healthy environment as opposed to a purely rights of nature base. But the language that we have here, does recognize the importance of the integrity of nature and things like that. So it's one of those incremental steps, and those. And so far, again, we're very close to the amount of signatures needed. Again, it's a great, a visual of where people are right now and how important they are seeing these rights. Yeah.
That's fantastic. Really appreciate your time today, Margaret, giving us this overview. As folks know, we're moving through some excellent overviews of what's going on in the rights of nature world around this beautiful planet. And Margaret, I now see that Natty Green from Ecuador has joined us and she's ready to go. So Margaret, thanks so much. And I hope you can stay on for a little bit longer. Otherwise, folks, keep an eye out. I'll be inviting Margaret back for longer discussions about Earth jurisprudence in particular in hopefully the early 2024. Is that next year? Early next year. I'm just suddenly challenged by this time-space continuum. I apologize. But look, a huge thank you, Margaret. I'm sorry with online, it's hard to get a feeling of appreciation, but I'm doing a daggy air clap for you and we'll see you very soon. Thanks so much for your time.